For judgment, item number 1.
It is therefore held that the claimant R1 has not been able to prove the negligence of the driver or the owner of the Scorpio number such and such, even on the touchstone of preponderance of probabilities. Consequently, the question of indemnifying the repair bills does not arise. The appeal is allowed.
Thank you, Lordship.
For admission, item number 2.
Before that, Lordship, I'd like to
Yes.
make a mention regarding one item from Part 2, Lordship.
Part 2.
Yes, Your Lordship.
Yes.
Item number 1, Lordship.
Okay.
Even as this item has now been fixed for today, my Lord. But now, since the council for respondent number 3, 1 to 3,
Number 3.
is not available today, my Lord.
Okay. You are for the petitioner.
Petitioner, Lordship. So it may kindly be taken up next week, Lordship.
Next week? It's okay.
3, 4.
Okay. Heard the counsel for the petitioner who has submitted that the respondent number, that the counsel appearing for respondent number 3 is not present today. Respondent number, you are for?
1, 2, 3.
1, 2, 3 is present. It is accordingly prayed that the matter may be listed next week, or accordingly list the matter in next week for hearing.
Your Lordship,
Can
on
I-
3rd of April, 3rd,
Third,
yes. Thursday, next week.
it's, you want a fixed date?
Yes.
Fix it on 3rd of April
Obliged.
for hearing.
Obliged, Your Lordship.
Lordship, Part 2, item number 9. Part 2, item number 9, Lordship. I am for the petitioner, Lordship. This may be taken up on Thursday, if possible, Lordship.
Other side?
Other side, it's the state government. I have taken the consent, Lordship.
Okay. Item 9, list the matter on Thursday as a fixed item on the prayer of the learned counsel for the petition.
Lordship, item number 7, this may be after a week, Lordship.
Item?
Number 7, Part 2.
Yes. Next week,
Next, after a week, Lordship.
after a week.
Lordship, yes.
Item 7, learned counsel for the petitioner has prayed for listing the matter next week. Other side?
Other side, it's
Other
not
side is
available
not
today.
Counsel for the respondents is not present today.
Regarding part item 1, Lordship, which I mentioned, my Lord, if it may be taken up before court number 1, because there was a related case to be listed on that date before court number 1, my Lord, on that
Similar matter.
similar matter. Court number 1.
Okay, that one on that was supposed to be on 3rd, no? Yeah, listed before court number
Obliged.
1. Yeah.
Item number 2.
Yes, I think this we have listed this because you were supposed to file. The government was supposed to file. Yes, respondent number 5
Yes, my lord.
was to file an additional affidavit. You have
yes,
not filed.
We'll be filing within the course of the day. my
During the
lord.
course of the
yes,
day.
We are.
So
we'll file
can we list it on Thursday then?
Yes.
Yes. On the prayer for the learned counsel for the respondent number 5, list the matter on Thursday as a fixed item.
Item number 3.
May it please, Your Lordship.
Yes.
My Lord, we have filed this instant second appeal under section 100 of the CPC. By way of an affidavit, I have submitted three proposed substantial question of law and they are yet to be formulated, Your Lordship.
Where is it?
By way of a separate sheet I have submitted, Your Lordship.
Okay. So, 1, 2, and 3. 3.
Yes, Your Lordship.
Who's appearing for the respondents?
Notice is yet to
Notice is yet to go.
Yet to go in the main appeal.
Okay. Let notice go first,
My Lord,
or we'll formulate the.
it has to be
response.
formulated first,
Yes, the
only
first.
then
Okay.
notice.
This is an appeal. This is a second appeal. Where is your cause title? Under section 100 of the CPC, read with section 17 of the Mizoram Civil Courts Act 2005, for setting aside and quashing the judgment and order dated 14/5/2024, passed in RFA 27 of 2023, passed by the Court of the Additional District and Sessions Judge Aizol, and order dated 27/7/2022, passed in probate case 22 of 2022 by the Court of the Senior Civil Judge Aizol. The petitioner, the appellant herein, has approached this court with three proposed substantial questions of law, being number 1, whether probate case number 22 of 2022 could be decided by the learned trial court without issuing any notice in violation of the principles of natural justice. Number 2, whether the will dated 3/10/2006 could have been probated in favor of the respondent in respect of the property which no longer existed when the probate case number 22 of 2022 was filed. And number 3, whether the will in probate case number 22 of 2022 could have been legally probated when the testator has bequeathed his property to two legatees, that is MS Ruthi RUTHI Lalrotfelli, and to anyone who looks after MS Ruthi Lalrotfelli, especially considering the fact that there are two guardianship certificates issued to MS Sai Pari and MS Rosang Zeli to look after MS Ruthi Lalrotfelli. Stop. This court is of the view that the above three proposed questions of law are fit to be formulated, and hence the said three proposed questions of law are formulated as questions to be adjudicated in the present second appeal. Stop. Issue notice to the respondents. How many respondents are there?
Sole respondent.
Issue notice to the sole respondent. You are appearing?
Yes, I'm appearing.
Okay.
I'm the main counsel.
Okay, okay. MS such and such appears for the sole respondent. And would you like to file an objection or anything?
Yes, my lord,
Yes.
because the proposed substantial question of law is in para number 13 of the petition.
Yes.
Yeah,
There's a
and-
separate application also.
Yeah, now filing the separate application without getting the court permission is
It's the
It's
same
strongly
substantial
object-
question of law. It's the same.
is strongly objected.
It's
If
the
it
same
is the
thing.
same, if it is the same substantial question of law, why it is necessary to file another?
Because there was,
application,
that is
No,
due
no.
to spelling mistake only.
It's okay because this can also be done separately also, and then inside it's the same thing in the appeal memo also, isn't it?
Yes, Your Lordship.
Yes, appeal memo is always same thing.
There was some clerical error, that's why.
That's why you filed this.
Yes, Your Lordship.
That is be issued after that. That
Only
I-
because of the clerical error, this has been filed.
I haven't seen the copy and let the notice be issued, and after that, I can decide whether I'm going to file the objection or not.
No, since you are appearing, no notice is necessary, isn't it?
Then the copy may be served to
But
me.
if you want some time to object, that's okay.
Yes, I need some
Yeah,
time to object. I just want to see the copy. I haven't seen the copy till yet.
We will
Okay,
furnish a
okay,
copy
okay.
during
You
the course of
furnish a
the
copy then
during the
today.
course of the
Yeah,
day.
yeah. The learned counsel for the petitioner is directed to furnish a copy of the appeal memo to the counsel for the sole respondent. Let the matter be listed after 3 weeks.
Yes, my lord.
After 3 weeks, in the meantime, learned counsel for the respondent may file their objections, if any.
Deeply obliged.
Item number 4.
What is this?
May I please, Your Lordship, before we go
Yes.
further into details,
Yes.
it seems we have come to an agreement that a rent may be deposited before the court, my lord. If Your Lordship kindly allows us.
And what
kindly
is
allows
this
that.
additional affidavit also?
Additional affidavit is their written objection submitted by the respondent before the trial court, my lord.
Additional affidavit not yet filed by the learned counsel for the appellant.
I have already filed, my
You have
lord.
filed?
Yes, my lord.
So today's, it's coming up for respondents are represented.
Yes.
my lord, I'm for the respondents.
Yes.
The dispute in this FAO is with regard to the rent
Okay.
accruing from the building. So, my learned friend has pressed for the rent to be deposited in the trial court. And my clients are willing to accept that on the condition that the rent will be disbursed once to the whoever gets the heirship certificate before the trial court.
Okay, okay. That's
And-
fair enough.
My lord, on one more condition that it will be with effect from the date of the disposal of RFA number 32 of 2022, because she has been forcefully collecting the rent.
Wait. What is the prayer in the petition, in the appeal memo?
In the appeal memo, my lord, I simply prayed for cancelling the order dated 18/9/2024, passing CMA 163 of 2024, my lord. But
So can it be disposed with this order to deposit the rent?
yes, my lord, if your lordship pleases.
Okay, okay.
But my lord, the
Yes.
effective date may be from the date of the disposal of the RFA.
Effective date of,
The effective date may be counted from,
for depositing the rent?
yes, because at this stage
Date
she has been
for-
forcefully collecting rent.
De-
And
depositing the rent
that is why,
may be with effect from, give the date.
just 1 second, my lord.
Yes.
with effect from 1/5/2023.
1/5/2023.
That is the date when the RFA number 32 of 2022 was disposed of by this honorable court.
RFA number
32 of 2022.
32 of 2022.
Yes, my lord.
22.
My lord,
Yes,
just one small submission.
yes.
Earlier rent collected when the respondents have not yet filed CMA 163 could not be later on deposited, my lord, as a bulk. So let the effective date be from the date of passing of order of CMA 163 of 2023, that is 6/3/2024, my lord.
Do you agree to that?
No, my lord, because
It will be a burdensome to us, my lord.
because
At the end of the day,
because-
we are all family members, my lord.
my lord, earlier what they've pressed is that, if I may take a lordship to my affidavit.
In that case, you give me the details, no? Starting how, regarding the earlier litigation also. Yes,
Because we've disputed the airship certificate.
Yes.
And airship by filing the RFA. And trial court, and the order of the trial court was set aside by this honorable court. By the order passing RFA. And this honorable court.
then it
had-
was remanded back.
It was remanded back. And this honorable court has passed an order that status quo as on the property in question should be maintained by the parties. And now we come to a dispute with regard to the status quo. Because they've stated that they've taken an earlier during the pendency of the RFA, but no counter statements have been made during the pendency of the said RFA when we say that we collected rent. But when the RFA was ultimately disposed of, they forcefully collected all the rents from the building. So now they are trying to gain some profit. That is what they are trying to do.
Then in this
Technically.
case, if the certain facts are disputed, shouldn't we go for a proper hearing? Because you're
If
saying
my
one
learned-
thing and
If
another
my
thing.
learned friend is unable to agree to 1/5/2023,
They are clearly unable to agree. That's what they're
if
saying.
my learned friend is willing to agree, then I am okay with it, my lord.
My lord, whether or not I'm willing,
Let's admit it and we can hear it.
yes,
Because you are disputing certain facts regarding the status quo date also you are disputing.
yes, my lord. Let it be admitted.
Yes. You are disputing the date also, isn't it, regarding the status quo as to when it should start, as to
Yes,
when,
my lord.
as to when it
Because
should operate.
after 1/5/2023,
Yes.
from January, she has been forcefully collecting the rent. That is the problem.
The
Yes, we'll see,
claim
we'll
of
have
the
to go through
respondents
the
that-
entire
my lord-
records. We can't just dispose like that then. We'll have to go through the records in that case.
Yes, my lord.
Heard learned counsel for the petitioner. Learned counsel for the sole respondent, isn't it? Sole respondent is also present. As all parties are represented, let the matter be admitted and fixed for hearing in usual course.
And
My lord, just one more,
once
one more
more
small
submission.
prayer.
Interim,
Yes, my lord.
What interim?
what interim?
My lord, I have made an interim prayer, my lord. Stay of operation of order dated 18/9/2024, my lord. They are filing,
My lord, at this stage, we're proceeding before the trial court in an application under Order 39, Rule 2A, because she has been forcefully taking the rent. And if I may take your lordship to just one small detail, that is page 8 of the counter affidavit filed by the respondents. WPC 61 of 2010.
Page 8, yes.
This is where the present appellant has been challenging the heirship certificate issued to her mother on the basis of
Airship certificate 167 of 2020.
Yes, it was issued to the mother, and she disputed during all her lifetime. By filing this writ petition, by filing a revision petition before the Sub-District Council Court as well. But when the mother died, she tried to grab everything. Even in her statement, my lord,
Anyway, staying the operation will not harm you in any way.
no, it
Just
will
for
harm
some
me
time.
because if your lordship stay the operation of that order, the trial court will not be able to proceed under Order 39 Rule 2A because he has been collecting the rent and enjoying the rent since 1/5/2023. Now it's 2025. All RSFs have been taken by
Okay, we'll give a short time then.
Yes,
Let
my
it
lord.
be listed for hearing next week.
Yes, madam.
Next week.
next week.
Next week, yes.
And my lord, one small submission. I've made some discrepancies with some small mistake with the annexure. So if I may be allowed to rectify the same from the registry.
Paging and all.
Pa-
or-
pagination,
It's
pagination.
okay, no problem. The respondent is allowed to make corrections in the affidavit.
Yes, counter
In the
affidavit.
counter affidavit. The registry is directed to allow the same. Next week, hearing.
Obliged, my lord.
Item number 5.
May I please, Your Lordship,
Yes.
this contempt petition is for not compliance of order of this honorable court order.
Government council.
The order was to conduct a spot verification, and it found that damage is done by the NF Railway. So verification is done, which I have already submitted in my short course reply.
Okay.
Verification is done by the DC Scholarship and Kala in this matter. Kala Scholarship, and then letter of intent is already sent by the government to the concerned NF Railway authorities. Now it is for the NF Railway authorities to come before this honorable court and state their
Give the status.
yes, because whatever steps that we have to take, and we have to.
So who is representing the NFR?
I believe none has presented the NF Railway as of now, and I don't know whether the notice is already complete or not.
We have already informed the council CGC that Mr. Mehdi, and he informed us that we will appear on behalf of the NF Railway. But as of now, he is on like in the another court.
Oh, then we can list it on another day. You inform him.
And still now, he didn't submit his power as per
Yes,
to my-
on the last occasion also, 24/2, it says, what's the name? Who is the newly impleted respondent then?
My lord, I represent respondent number 10. That is the the new Kala Scholarship.
Okay.
But nevertheless, what have to be stated before this honorable court is the same with respondent number 3, which I am representing.
Oh, okay.
Because no one
Same
is-
submissions,
Yes.
same submissions. And the railway is respondent number 6.
Yes, madam.
No, 4, 5, 6. Till 7, I think. 4, 5, 6, 7. Isn't it?
Yes, still 7.
4, 5, 6, 7. Learned Petitioners Council is present. Learned Council MS Mary Kyangte appearing for respondent number 3, and the newly impleted respondent number 10 has submitted that the respondent number 3 and 10 have already complied with the directions of this honorable court, and the letter of intent has already been sent to the NF Railway authorities. However, none appears for respondent number 4, 5, 6 and 7 today when the matter is called. Accordingly, list the matter next week.
Yes, madam.
List the matter next week, and the learned counsel for the petitioner shall inform the CGC
Yes.
okay, about the listing of the matter.
For orders, item number 6.
May it please your lordship,
Yes.
I am for the appellant.
Okay.
Step has been taken for service of notice upon the respondent.
Anyone appearing for respondents?
Lordship, I'm representing the respondent number 2 in item number 6.
Respondent number 2.
True, Lordship, yes.
One, 3 and 4. You are the claimant.
Yes,
you-
I'm the
you
claimant
the
for
claimant?
the learned tribunal. Lordship.
Okay. And 1, 3 and 4, are they the driver and owners?
Drivers, yeah.
Learned counsel for the appellant is present. Learned counsel Shri such and such appears for respondent number 2 / claimant. 2 or 3? 2.
True, Lordship.
Mm.
As it is.
Respondent number 1, 3 and 4 are not represented today. Has notice come back? Has it returned? Postal receipt.
It should be 1 and 2.
Okay, postal receipt has been received. From the office note dated 3/3/25, it appears that postal receipts have been received from the postal office on behalf of respondents number 1, 2, 3 and 4. Accordingly, we'll just give little time
Yes,
in
Lordship.
case the appeal. List the matter after 2 weeks, awaiting the appearance of respondent number 1, 3 and 4.
Item number 7.
Your lordship,
This is also
7 and 8, 6, 7 and 8 are analogous case.
analogous. Okay. 6, 7 and 8, same order. Okay. So you appear for R2 in all.
No, Your Lordship. And, item number 7, I'm representing respondent number 1 only.
Okay. In item number 7, you are
Johnny.
your name on Johnny here appears for respondent number 1 in MSc 2 of 2025,
Lordship, yes.
and the other respondents are not represented, na?
Not
Here also.
represented.
So, in this matter also, respondent number 2 and 3 are not represented. Office note dated 24/3/2025 indicates that service report has not returned back from respondent number 2 till date. And in respect of respondent number 3, the notice has returned unserved with a postal note, insufficient addressed, not found. You try again for R3 then.
R3.
It says insufficient address, not found.
R3, that's one.
R3. R3 in MSc 2 of 25.
If I may allow to serve by dusty service.
Okay.
Okay.
The appellant is allowed to take steps on respondent number 3 by dusty service and thereafter file an affidavit to that effect.
Your lordship, even in MSc 1 also.
1 also?
No, I think 1 or
in-
MSc 1 notice are
No,
completed.
MSc 1 postal receipts have returned.
Yes.
Oh,
We just have to await. Then MEC 2, respondent 3 to Dusty Service. And then await service on respondent number 2 and 3. This is the matter after 2 weeks. And appellant shall take steps within
1 week.
within 1 week. Then item 8.
Item 8.
Item 8 also, let's see the record.
Also in item 8, I'm representing respondent number 1 and 2.
Okay.
1 and 2.
Okay. In item 8, counsel for appellant present, learned counsel Sri Johnny appears for respondent number 1 and 2. Notice on respondent number 3 has not returned. Stop. Accordingly, list the matter after 2 weeks, awaiting service of notice on respondent number 3.
Your Lordship, in respect of 4, is there any return?
After?
There is 4 respondents in this case.
There are 4 respondents.
Yes, Your Lordship.
Same here also, respondent number 4 incomplete address. So same thing, Dusty Service. On respondent number 4, the appellant shall take steps by Dusty Service and thereafter file affidavit.
Thank you, Your Lordship.
Item number 9.
Bail.
My Lord,
Yes.
this is an application under Section 37 of the NDNPS Act, read with Section 483 of the BNSS, my Lord. So, my Lord, if I may first read the report of Caesar and arrest to make the picture clear regarding the allegation against me, my Lord. It is at page 26, my Lord.
Yes. Page 26.
26, my Lord, yes. If I may read, my Lord.
Yes.
To the officer in charge, ANS Excise and Narcotics, subject report of Caesar and arrest, reference case, excise case number so-and-so, date so-and-so, under Section 21C of the NDNPS Act 85. Sir, I have the honor to report that in the subsequent investigation of case number that I have cited above, I seized the below noted articles on this day of 8/6/2023 at 7:50 p.m. at Kolasip Biarko and Khan Molveng, Kolasip as a subsequent seizure of this instant case in the presence of 2 civilian witnesses and 1 witness from excise and narcotics personnel. In connection with the seized article, I arrested the below noted person on the same date, time and place. Arrested person, Boris Lalherliana, son of so-and-so, resident of Biarko and Khan Molveng, Kolasip, seized article 354. The seized articles were taken out by the arrested person from under the grass besides the footstep, which was located about 15 meters away to the northwest of the residence of the arrested person. The seized articles were kept in 3 bundles. 2 bundles contained 11 soap cases each, and the remaining bundle containing 5 soap cases. Each of the bundles was kept in black polythene and each of them was sealed with a brown tape. I examined the accused Boris Lalherliana at the office, and he told me that the heroin bought by his father had been hidden by him at the instruction of his father through phone call. While he ran away to escape arrest, as a dutiful son, he obeyed his father's wishes and put the drugs in a garbage bag which he kept under the grass beyond his compound. When I examined Boris Lalherliana, he willingly cooperated with me and he disclosed everything about his father's involvement, where he hid the drugs. As per information received from him, I recovered the seized suspected heroin and arrested him to be released as soon as his father could be arrested, as his father was still in hiding. Boris Lalherliana cooperated with me every time. I requested him and he should not be held accountable for obeying his father.
On 9/6/2023, PC Lalrin Moya, he is the petitioner, my lord,
Okay.
who is the father of the arrested person, Boris Lal Herliana, was reported himself at the station. And I therefore arrested the cited PC Lalrin Moya, son of so-and-so, resident of so-and-so, on the same date at 2 p.m. at Commissionerate of Excise and Narcotics for possession of the seized 354 grams of suspected heroin kept in 27 soap cases. I examined the accused PC Lalrin Moya, who told me that the seized heroin which I seized from his possession were sent to him by Van Lal Kung Kui, which he received on 1/6/2023 at Colosip from Mexicap Sumo concealed in Dai Tobacco. I also released Boris Lal Herliana as the real owner. PC Lalrin Moya has been arrested. I request you to kindly encase the accused PC Lalrin Moya under the case shown above. My lord, the seized 354 grams was seized at the instance of my son. And then on the next day, I surrendered myself before the excise, and then my son was released and discharged from prosecution. So my lord, before the seizure was made near my residence, on 27th of May 2023, 1,537 grams of heroin, which were kept in a mattress, inside a mattress, and a parcel box were seized in front of the Excise and Commissionerate office at Aizawl. And then the suspected possessor, Ms. Van Ram Moyi and her husband, Van Lal Khrieta, were arrested on the same date. And then the case was registered. An investigation was going on. And then as per the statement of the two arrested persons, Van Ram Moyi and Van Lal Khrieta, so the mattress to be delivered to Ruthilal Duomi at Vairengte. And then the seizing party went to Vairengte, and Ruthilal Duomi and her friend, Mr. John Silal Mangaya, were arrested on 2/6/2023. And then based on their disclosure statement, another 112 grams of heroin was seized from the residence of John Silal Mangaya on 6/6/2023. That is the genesis of the case, my lord. It's a long story, my lord. So, my lord, there is one thing I would like to bring to your lordship kind notice is that the accused, Van Ram Moyi and her husband, Mr. Van Lal Khrieta, from whose possession 1,537 grams were seized, they were discharged from prosecution.
Discharged?
Yes, my lord. And then the accused Ruthilal Duomi and Ruthilal Duomi, John Silal Mangaya, and the present petitioner are facing trial, my lord. And then, my lord, Ruthilal Duomi...
Trial started already?
My
Trial
lord,
commenced already? Trial has
on
commenced?
3rd of March, yes, it was already commenced. 3rd of March, charge was framed only, my lord. No witnesses has been examined till then, my lord.
Okay.
So, my lord, Ruthilal Duomi and John Silal Mangaya were also released on bail, my lord. Only the present petitioner is being kept behind bar till then, my lord. So, my lord, my grounds is very limited, my
He
lord.
was arrested on 9/6/23.
23, my lord.
9/6/2023.
My lord, my first contention, my first ground is that with regard to the present petitioner, this is the first time of prosecution before the court of law. And no contraband article was recovered from my position. I was not present at the PO. So as per the allegation, I instructed my son through phone call to hide the contraband article. But my mobile phone were not seized. There is nothing material has been collected, my lord, only based on the statement, my lord. So my next contention is that that is my main ground, my lord.
Okay.
The present petitioner was arrested on 9/6/2023, and he is being detained in custody for more than 1 year and 9 months, my lord. The prosecution cited as many as 18 witnesses, and no witnesses has been examined till that, my lord. So the charge was framed only on 3rd of March this year, 2025, and therefore the trial is at the preliminary stage.
Charge framed on?
3/3/2025, my lord.
2025.
My lord, if I may kindly produce the copy of charge frame, my lord. My Lord, charge sheet was filed on 21/2/2023. And then the trial is at a preliminary stage, and there is no likelihood that it would be completed in the near future, my Lord. So, Your Lordship, the reason for delay cannot be attributable to the act of the present petitioner because he is being kept behind bar till his arrest, since his arrest. So, the prolonged incarceration militates against the most precious fundamental rights guaranteed under Article 21 of the Constitution of India. And then, on that ground alone, my Lord, he may be granted bail without going into the merits of the case, my Lord. So, my Lord, I have the authority to support my submission, my Lord.
Okay, let's see. Regarding long trial.
Yes, my Lord. My Lord, one is 2022 SCC Online SC 2068, my Lord. That the relevant para is at para 3 and para 4, my Lord.
Yes.
If I may read, my Lord.
Okay.
During the course of the hearing, we are informed that the petitioner has undergone custody for a period of 1 year and 7 months as on 9/6/2022. The trial is at a preliminary stage as only one witness has been examined. The petitioner does not have any criminal antecedents. Taking into consideration the period of sentence undergone by the petitioner and all the attending circumstances, but without expressing any views in the merits of the case, we are inclined to grant bail to the petitioner. My Lord, here in this case, the petitioner are detained in 1 year, 7 months. One witness has been examined, but in my case, my Lord,
no witness.
no witness out of 18 witnesses, my Lord.
One year,
9 months.
9 months. Okay, then the other
Next
one.
is, my Lord, 2023 Life Law SC 533.
Para.
Para 4, my Lord. If I may read, my Lord.
Yes.
As regard to the twin conditions contained in Section 37 of the NDPS Act, Learned Counsel for the respondent state has been duly heard. Thus, the first condition stands complied with. So far as the second condition, formation of opinion as to whether there are reasonable grounds to believe that the petitioner is not guilty. The same may not be formed at this stage when he has already spent more than 3.5 years in custody. My Lord, I would like to stress upon the next line. The prolonged incarceration generally militates against the most precious fundamental right guaranteed under Article 21 of the Constitution, and in such a situation, the conditional liberty must override the statutory embargo created under Section 37(1)(b) inside bracket 2 of the NDPS Act, my Lord.
Okay.
And my Lord, based on the Honorable Apex Court judgment, my Lord, a coordinate bench of this court has made an order. That is the bail application number 610 of 2024. Abdul Manan Ali. My Lord, the relevant para are paragraph 11, 12, 13, 14, 15, 16,
Okay.
if I may read, my Lord.
Mostly para 16, I think.
Yes. Okay. Para 11, my Lord.
Yes.
It appears that since the date of his arrest on 30/1/2023, The petitioner has been detained behind the bars, and though a period of 1 year, 6 months have lapsed, however, till now, only 1 out of 9 listed prosecution witness has been examined till now, and there is unlikelihood of early culmination of the trial. Para 12. The Supreme Court of India in Mohammed Muslim at Hussain versus State and City of Delhi reported in 2023, SCC Online SC 352 has observed that grant of bail on the ground of undue delay in trial cannot be said to be fettered by Section 37 of the NDPS Act 1985. Para 13. The Apex Court in Rabi Prakash versus State of Orissa reported in 2023 Life Law SC 5TT, wherein it has been observed by the Apex Court that the prolonged incarceration generally militates against the most precious fundamental right guaranteed under Article 21 of the Constitution, and in such a situation, the conditional liberty must override the statutory embargo created under Section 37(1) B(2) of the NDPS Act 14. It appears on perusal of the rulings cited by learned counsels for the petitioners that in all cases cited by the petitioner, though commercial quantity of contraband was involved, and apparently the embargo of Section 37 would have been applicable in those cases, however, only because of the fact of prolonged incarceration of the petitioners, the Apex Court allowed the petitioners to go on bail. Para 15. In view of the observation made by the Apex Court, this court is of the considered opinion that if under the facts and circumstances of a case, this court comes to the finding that there is undue delay in the completion of the trial and that the incarceration of the petitioner is long enough, he would be entitled to get bail on the ground of such prolonged incarceration. As such, in a case of prolonged incarceration, the right to life and personal liberty guaranteed to the petitioner under Article 21 of the Constitution of India would outweigh the fetter imposed under Section 37 of the NDPS Act. Para 16. In the instant case also, the present petitioner has been detained behind the bars for more than 1 year and 6 months, and there is unlikelihood of early culmination of the trial. Hence, in view of the facts and circumstances of the case, as well as considering the observations made by the Apex Court in the rulings cited herein above, wherein it has dealt with the question of long incarceration, similarly situated petitioners were before the Apex Court. This court is of the considered opinion that in the instant case also, the facts and circumstances are such that long incarceration of the present petitioner outweighs the embargo of Section 37 of the NDPS Act 1985, and the petitioner is therefore entitled to get bail on the ground of prolonged incarceration only. My Lord, in this case also, the petitioner was kept behind by 1 year and 6 months. Out of 9 witnesses, only 1 witness has been examined, my Lord. So, my Lord, my humble submission is that without going into the merits of the case, my Lord, I humbly pray your Lordship to release the present petitioner due to prolonged incarceration. My Lord, that is my submission, my Lord.
Yes, PP. Charge sheet is dated 27/5/23. Charge sheet.
Yes, 21/2, my Lord. 21/2/2024.
21/2/24.
Oh, yes.
21/2/24. Yes.
Yes, my Lord.
Yes.
From the record itself, my Lord, it can be seen that the accused has conscious possession of the seized contraband substances. So, my Lord, one of the requisite element of the NDPS Act is conscious and knowledge of possession of the contraband articles. So, my Lord, here in this case, I would like to take you to the statement of the accused himself. That is in page 56, my Lord.
Yes.
If I may read.
Yes.
My name is P.C. Lalin Moya. My father's name is P.C. Thanpuangalit, and currently I am living in Colosip, Diakon. I was a member of Indian Army, and in 2011 I was retired as recharge pension, and currently my occupation is auto driver. I sell heroin since 2021, And when I started selling heroin, I procured the same from Lalrin Moi of Chimluang, Kolosip district. Since Lalrin Moi was arrested in the year 2023, Timboy of Chimluang introduced me to Vandal Kung Pui. Here, my lord, the whole seized contraband was supplied by Vandal Kung Pui, and she is still not arrested till now.
Absconding.
Since then, I bought heroin from Vandal Kung Pui, and when she sent, she had to conceal inside egg parcel, cabbage, and second-hand bale. I brought heroin from Vandal Kung Pui at the rate of rupees 14,000 per home, and sold it at the rate of rupees 17,000 per home. Sometimes she had to send me 11 hongs, 22 hongs, and sometimes 44 hongs. Usually she had to send me when she sent it to Vairengte, and when she did not send me, I bought it from my co-accused Valpuya and Ruthi Lalduomi, and Valpuya and Ruthi had to come to Chimluang by ecovan and delivered it to me. When I bought it from them, I paid rupees 15,000 per hong, and usually I bought 10 hongs to 20 hongs at a time from Valpuya and Ruthi. The sale proceed I have received were delivered it again to Ruthi and Valpuya, but once I paid by way of GPay through Vandal Thori of Lunglei and transferred it to Vandal Kung Pui for 2 times. I had never made order to Vandal Kung Pui, and she had to send me heroin when she thinks it necessary. On 27/5/2023, Vandal Kung Pui contacted me and informed me that heroin concealed in egg parcel was seized in Aizawl, and I would have none to receive. On 1st June 2023, Vandal Kung Pui contacted me and told me that heroin concealed in tobacco bags where a letter N was written to be delivered to me, and the same was sent by Champhai Sumo. Therefore, I went to Keicham Junction and I received 2 bags where heroin were kept from Champhai Sumo. I took out 44 hongs of heroin from the bags and brought them towards my residence, but I disposed the bags at Rengtekon. While I was approaching my home, I sold some of the heroin to my customers who are from Bhairavi and Kolosip by way of credit. It came into my knowledge that Excise and Narcotic Aizawl had arrested Valpuya and Ruthi, and I was also looking by them through Vandal Kung Pui's message, and as such I absconded. I told my son Boris Lalherliana the place where I hid heroin and instructed him to hide it somewhere else, despite I had never wished my son to be involved. But the situation warrants and instructed my son to hide it somewhere. Heroin 27 hongs, that is 354 grams, which was seized by Excise and Narcotic on 9/6/2023 from the possession of my son, was obtained by me from Vandal Kung Pui. My son had never involved in dealing a heroin, and he was hiding it as per my instruction as obedient son. That 11 hongs of 11 heroin concealed inside a parcel box seized by Excise and Narcotics on 27/5/2023 was sent by Vandal Kung Pui and to be delivered to me. So, my lord, here it is very clear that he used to deal with these contraband drugs from quite a long time, and he is having a conscious possession. And my lord, without having satisfaction, the embargo of Section 37, only on the grounds of long incarceration, an accused cannot be released on bail, my lord. And considering the gravity of the offense involved, the impact and the menace of the drugs in the society, my lord, this instant petition shall be rejected for the interests of justice, my lord.
But the recent trend is that Section 37 also there can be exceptions. The Supreme Court has already said on several occasions, no?
Yes, my lord.
And since the Accused is a resident of Mizoram only, so
Yes.
And
if stringent
my-
conditions are put,
My
I-
lord,
Yes.
my another submission is that since the main supplier, Vanal Pungpui, is still not arrested,
that I
And
will reflect.
there is a highly possibility that the accused will indulge in the same business, commit the same offense while he is released on bail, my lord.
Main supplier was this Vanlal
Vanal Pungpui.
Vanlal Pungpui.
And also, my lord, looking into the merits of the case, there is a high chance of convicting the accused.
That is not an issue. Prima facie case is there for sure.
Yes, my lord.
Subsequently, okay, right. This is an application under section 483 of the BNSS 2023, read with section 37 of the NDPS Act 1985, praying for enlarging the accused / petitioner on bail pending trial in what is SR, capital SR under bracket EX number 49/2024, reference dash excise case number EX.N capital dash 146/2023 under section 21 under bracket C of the NDPS Act 1985. The case of the petitioner / accused is that on 27/5/2023, 121 soap cases containing 1,537 grams of heroin, which was kept and concealed inside a mattress and egg parcel box, were recovered. In connection with the seizure of 1,537 grams of heroin, Vanram Mawi, VANRAMMAWI, and Vanlal Riata were arrested on the same date, and excise case number EXN-146/2023 was registered for the offense under 21C of the NDPS Act. During investigation and on interrogation of the accused persons and basing on their statements, one Ruti Laltuhuami and John C. Lalmanghaeha were arrested on 2/6/2023 at Vairingte. Based on the statements of the arrested persons, 2,112 grams of heroin in 165 soap cases was seized on 6/6/2023 from inside the residence of accused John C. Lalmanghaeha. After seizure was effected, based on the statements of the accused Ruti Laltuhuami and John C. Lalmanghaeha, another 354 grams of heroin in 27 soap cases was recovered and seized under a bush near the present petitioner / accused house on 8/6/2023. And the son of the present accused petitioner was arrested in this connection on 8/6/2023. Mr. Boris Lalerliana, the son of the petitioner / accused, stated to the investigating officer that the seized 354 grams of heroin was concealed by him on the instruction of his father. Therefore, the present petitioner / accused was arrested on 9/6/2023 when he voluntarily surrendered before the officer in charge of the excise and narcotics, Aizol. Stop. It is stated that the charge sheet in the present case was filed on 21/2/2024 and charge was framed against the present accused / petitioner on 3/3/2025. Stop. It is the contention of the learned counsel for the petitioner / accused that he has now been in custody for a period of 1 year, 8 months.
9 months, my lord.
1 year, 9 months, till the time of the filing of this bail application. Stop. The prosecution has furnished a list of 18 witnesses, but till date, no prosecution witness has been examined, and therefore the trial is at a preliminary stage and there is no likelihood that it would be completed soon in the near future. It is also the contention of the learned counsel for the petitioner / accused that the reason for delay of the trial cannot be attributed to the petitioner, as he is in custody since he was arrested on 9/6/2023. Stop. He has also submitted that prolonged incarceration militates against the most fundamental rights guaranteed under Article 21 of the Constitution, and in such a situation, the conditional liberty must override the statutory embargo created under Section 37 of the NDPS Act. Stop. It is further submitted that the petitioner is a permanent resident of Daikwan, Kolasip, and therefore there is no reason for him to abscond even if he is released on bail. Stop. The petitioner, the learned counsel for the petitioner accused has referred to the judgments of the Honorable Supreme Court in 2023 Live Law under bracket SC 533 in the case of Rabi Prakash versus State of Odisha, and also 2022 SCC Online SC 2068 in the case of Nitish Adhikari alias Bapan versus State of West Bengal. Stop. Relying on the above judgments, the learned counsel for the petitioner / accused states that the Honorable Supreme Court has laid down in the above stated cases that prolonged incarceration generally militates against the most precious fundamental right under Article 21 of the Constitution, and in such situations the conditional liberty must override the statutory embargo created under Section 37 of the NDPS Act. Stop. The Supreme Court in the case of Nitish Adhikari alias Bapan Supra has also stated that the petitioner in the instant case had undergone custody for a period of 1 year and 7 months, and the trial was at a preliminary stage as only one witness had been examined. Moreover, the petitioner did not have any criminal antecedents. Therefore, the Honorable Apex Court had expressed the view that the period undergone, taking into consideration the period of sentence undergone by the petitioner and all the attending circumstances, but without expressing any view on the merit of the case, the court had allowed bail to the petitioner. Stop. Learned counsel for the accused petitioner also refers to a judgment of a coordinate bench of this court in bail application 610 of 2024, where the court was faced with a similar situation, the accused having undergone incarceration for 1 year, 6 months. And in that case also, out of 9 prosecution witnesses, only 1 had been examined, and therefore the court allowed the bail application of the petitioner accused, who was languishing in jail in a case, there also it was 21C,
Yes,
in
my
a
lord.
case where he was charged under 21C of the section 21C of the NDPS Act 1985. Stop. Accordingly, learned counsel for the accused / petitioner prays that he may be allowed to go on bail in the present case. Stop. Next para. Learned PP, MS, yeah, her name, appearing for the state respondent.
Additional PP, my lord.
Additional PP, okay, additional PP, appearing for the state respondents, has vehemently objected to the arguments put forward by the petitioner accused. It is stated that as per the records, the petitioner accused was in conscious possession of the contraband substance, and she has drawn the attention of this court to the statement of the accused during investigation at page 56 of the petition, at page 56 of the present petition, wherein the petitioner accused had clearly admitted that he was selling heroin since 2021, and that he used to receive the contraband substance from one Vanlal Kungpui. He has also stated in his statement that the heroin 27 hongs, that is 354 grams, which was seized by Excise and Narcotics on 9/6/2023 from the possession of his son, was obtained by him from Vanlal Kungpui. Stop. He stated that his son had never involved in dealing of heroin, and he was hiding it as per his instructions. Stop. That the 11 hongs of heroin concealed inside egg parcel box seized by excise and narcotics on 27/5/23 was sent by Vanlal Kungpui and was to be delivered to him. Stop. Learned additional PP submits that the rigors, RIGORS, rigors of Section 37 NTPS Act are clearly applicable in the present case, and if released, the accused/petitioner is likely to indulge in the offense again. And it is also pertinent that the main supplier, Vanlal Kungpui, is absconding and is yet to be apprehended. Stop. And therefore, there is ample apprehension that the accused may indulge in the offense again if released on bail. Stop. Next para. This court has considered the submissions of the parties and has also perused the judgments of the Honorable Court, of the Honorable Supreme Court, as produced by the counsel for the petitioner accused. Stop. In the present case, the records show that petitioner was arrested on 9/6/2023 and he has been in custody since then. It is now more than 1 year 9 months since his arrest, and as seen from the records, charge has been framed against the petitioner accused on 3/3/25, but none of the prosecution witnesses have been examined till date. How many prosecution witnesses you were saying?
18, my lord.
18?
Yes.
It is also seen that the prosecution has furnished a list of 18 prosecution witnesses to be examined in the present case. And it goes without saying that the trial will certainly continue for a long time. Stop. Accordingly, this court, on consideration of the facts and circumstances in the present case, is of the view that the petitioner accused can be released on bail at this stage, having had to undergo incarceration for 1 year 9 months, and also in view of the fact that the trial is not likely to be completed soon in the near future. And therefore, this application is allowed. Stop. The accused petitioner shall execute a bail bond of rupees 30,000 with 2 sureties of like amount to the satisfaction of which court? To the satisfaction of NDPS court, special court.
Yes. My lord.
Satisfaction of the special court and the NPS Act. Aizol.
My lord.
Aizol. And any other conditions that the learned trial court may impose in order to secure the presence of the petitioner accused during the trial. Stop. If the petitioner accused violates any of the conditions imposed by the trial court, it shall be seen as a violation of the bail conditions and the bail shall be liable to be cancelled. Stop. The petitioners accused shall also not leave the jurisdiction of the trial court without permission of the trial court. Stop. Application stands disposed.
Highly obliged.
Item number 10.
May I please, Your Lordship, this ayah is about condonation of
Delay.
delay 93 days, delay of 93 days in filing the connected criminal appeal number 7 of 2025.
93 days.
Yes, my lord.
Who's appearing for state? Any objection?
No, my lord, I have no objection.
Okay, I 13 of 25. This is an application under Section 5 of the Limitation Act 1963, praying for condoning delay of 93 days in filing the connected appeal number
7, my lord.
appeal numbers, criminal appeal number 7 of 2025. Stop. Your grounds, where are your grounds? Para 2.
Yes, para 2,
Para 2.
from sub number A.
Yes. Learned counsel for the applicant has stated at para 2 of the application that the applicant was convicted on 18/10/2024 and sentenced on 18/10/2024 by the Special Judge NDNPS Champai, White, judgment and order dated 18/10/24, and he was immediately forwarded to the District Jail Champai. Stop. Immediately upon getting knowledge about the conviction, the applicant had informed his relatives that he wishes to prefer an appeal against the impugned judgment and order dated 18/10/2024. Stop. Accordingly, the relatives of the applicant had engaged a lawyer for her on 14/2/2025, by which time 93 days had already lapsed for filing the present criminal appeal. It is also stated that the counsel for the applicant had applied for a CTC of the judgment and order dated 18/10/24 on 21/2/25, and a copy of the impugned judgment and order was received on 24/2/25. Stop. Thereafter, the counsel for the applicant had taken about 34 days to study and prepare the appeal memo, and hence the present application was filed on 20th March 2025, thereby causing a delay of 93 days. Stop. He has therefore prayed that in the interest of justice, the delay of 93 days may be condoned and the present criminal appeal number 7 of 2025 may be admitted. Stop. Learned additional PP, MS such and such appears for the state respondents and states that she has no objection to the prayer for continuation of delay. Stop. In view of such facts and circumstances, the application is allowed and the delay of 93 days is condoned. The application stands disposed. Then main criminal petition. You come to Criminal Appeal 7 of 25. In view of the order passed in IA Criminal 13 of 2025, this appeal is admitted, or is it? It's already admitted, no? This appeal is listed for hearing. We can list it for hearing now. Or paper book. We have to call for the LCR.
Yes.
Accordingly, LCR is called for. The registry shall obtain the LCR from the learned trial court, and the matter may be listed after 2 weeks.
Item number
Obliged,
11.
my lord.
May it please your lordship,
Yes.
two interlocutory application has been filed, and which is IA 206 of 2024 is an application for continuation of delay of 49 days.
Okay.
Lordship,
Yes.
with regard to that, I will be filing my affidavit in opposition during the course of the day. So,
49 days.
yes, Lordship.
You want to object?
Yes, Lordship.
Okay.
My lord, I have strongly objected my learned friend's prayer, because as per the last court date, that is 25th of February, 2 weeks time has already been given to my learned friend. And now,
For filing the objection?
Yes, your lordship. And
Yes,
today
Lordship.
is
Why
exactly
do you-
1 month.
Why do you want to object to 49 days delay?
Lordship, because that 49 days, two-thirds of the delayed days are not explained, and there is no sufficient
No sufficient cause?
yes, to condone their
But
application.
we are not inclined to give you too much time. Maybe 1 week, next week.
Yes, Lordship, no
Next
problem.
week. Okay. We have already taken so much time.
Yes, Lordship.
My lordship.
Yes.
And
As a last
one-
chance. Yeah.
Okay.
1 week.
And one IA 48 of 2025 has been filed. Application that
For
is
stay.
application for stay. Yes, my
But-
lord. Execution.
But we
has-
have to consider the condonation first, no?
Yeah, it is correct, your lordship. But my building is under lock and key now, because they have, the respondent has filed execution case. So
There is
in-
urgency, that's
yes, yes, your lordship. So
So we'll give a fixed date next week.
at
Yes,
least,
lordship.
your lordship, at least Thursday. This Thursday.
This Thursday?
Yes.
Can you file by tomorrow?
Lordship, can it be taken up after a week so that
Your lordship, if I'm not wrong,
Monday,
I've heard
Monday.
that he is trying to file his affidavit in opposition today itself.
yes, Lordship,
Yes,
that-
that was
Today
his
itself?
submission,
Yes.
yes.
Okay. Then Thursday
Thursday, your lordship.
or Friday?
Friday, Lordship.
Friday.
Thursday, your lordship, because that building is my main source of income.
One
and
day,
it is
one day
it
will
is
not
only
make a
about-
difference.
Okay,
One
yes.
day, yeah. So this condonation is IA 206, no? No, 48.
And Lordship,
48 is for stay application,
Oh,
application
48
for
is-
stay, your lordship.
Lordship, only one last thing.
Yes.
We haven't received that IA 48 of 25.
Yes, your lordship, IA 48 is listed for the first time today. So,
So give copy.
yes,
Yeah.
yes, your lordship.
So IA 48 and IA 48 and one is IA 206, right?
Yes, your
206 is for
Condonation of
condonation. Okay. In IA 206, heard learned counsel for the parties. Learned counsel for the respondent has prayed for a few days' time to file his objection to the prayer for condonation. It is submitted that the application is the written objection is ready for filing. Accordingly, the learned counsel for the respondent shall file the same during the course of the day. Okay, and the matter may be listed on Friday. 28 on 28. Yes.
Obliged, Lordship.
No, it is stated that no further time will be granted for filing the objections.
Obliged, Lordship.
Part 2 hearing, item number 8.
My Lord,
Yes.
I have a limited prayer in this regard, my Lord.
Okay.
The,
What is it?
The issue is that the Learned First Appellate Court,
Hmm.
instead of deciding the case on merit,
Hmm.
has remanded back the case to the civil court, the trial court,
Hmm.
for deciding the case again
Hmm.
at the stage, from the stage of frame of issues.
Hmm.
Now, my main grounds is that
Hmm.
the Learned First Appellate Court could not have remanded the case back.
Hmm.
So there is only the issue. Your Lordship will see that under Order
So
41,
you want that it should be
Decided on merit.
by this court on merit?
decided by the Learned First
By
Appellate
the
Court.
Learned First Appellate Court.
Yes, let the case be decided on merit because there are ample evidence, enough evidence for the Learned First Appellate Court to decide the case on merit. Now, in the impugned judgment, your Lordship will see, there is on page 41, Madam.
Page?
41. Para 11.
Yes.
With your Lordship permission.
Yes.
With the above reasons and finding, the installed appeal is allowed to the extent that the impugned judgment and order dated 18/10/2021 along with decree dated 18/10/2021 passed by the London Senior Civil Judge for Azol District in Civil Suit number 111 of 2011 is hereby citizen and quash due to non-consideration of counterclaim preferred by the appellant defendant number 1 and number 2. The suit is sent back for trial de novo from the stage of settlement of issues in relation to the counterclaim made by the appellants defendant number 1 and number 2. Now in this case, my Lord, the Learned Trial Court has framed 17 issues initially. Now that 17 issues is reduced to 3 issues. Now the 3 issues covers the case of the defendant as well. The counterclaim was decided in that 3 issues. Now this observation and finding made by the Learned First Appellate Court is wrong. Due to the fact that your Lordship will see Order 41, Rule 23, CPC. Now this is a situation where a case can be remanded back. In my case, pleadings were there, evidence were taken. The case was not disposed on a preliminary point. Now, if I may read this,
Yes.
where the court from whose decree an appeal is preferred has disposed of the suit upon a preliminary point. A preliminary point would be on the basis of issue of limitation or any other ground or non-payment of court fees.
Maintainability and all.
Maintainability. Now in our case, my Lord, your Lordship will see page 42 to 86 is the judgment of the trial court.
Okay.
42 and 86.
Page 42 to
86.
86.
Your Lordship will kindly come at page 45, para 6.
Page 45. Okay.
These are the 3 issues which covers the instant case. Now, if your Lordship will come at para 7, the plaintiff examined himself and one other witness to prove his case. The defendant examined themselves and one other witness to prove their case. The defendant number 3 to 7, who are the state respondents, examined only one witness. Now, we have a record of the evidence in the trial court. Now, this is not a case where it was decided on a preliminary point. It was decided on merit. The 3 issues are answered by the trial court. Lordship will come at page 81. I was the successful party in the trial court, my lord. 81 is the order, my lord.
Okay.
With your lordship permission.
Yes, please read.
On careful reading of the above report, it clearly shows that Pu Pazona does not have any pass or permit which can be mutated into land settlement certificate. Despite this fact, the cadastral surveyor has taken measurement of his house, which was constructed within the landed property covered by periodic pata numbers 377 of 1978. 377 of 1978 is my land pass.
Okay.
In the name of the plaintiff, Varal Moy at the time. But no objection certificate was not obtained from the plaintiff before LSC number so-and-so, and LSC number so-and-so was issued in the name of Pu Pazona, represented by Vanal Thanpoe and the defendant number 2. For the above reason, I hereby declare that the LSC number so-and-so issued in the name of the defendant number 1 and 2 was illegally issued by the defendant number 3 to 7. Since the issuance of the LSC number so-and-so has been declared illegal, the said LSC are hereby cancelled. Now these LSCs overlap my land, that is periodic pata, so the LSC was cancelled. So if we refer to Order 41, Rule 23, my lord, this case was not disposed on a preliminary point. It was decided on merit. The trial court based its decision on the evidence available on record, my lord. So being aggrieved by this order, the defendant number 1 and 2 has preferred an appeal before the first appellate court. Now the first appellate court, without properly considering the evidence on record and the laws concerning remand of a case, has...
The appellate court did not discuss the issues.
No, the appellate court has not satisfied itself with regard to Order 41, Rule 23, Rule 23, Subclause A, and Rule 24. Your Lordship may kindly come at Rule 24. Rule 24. Where evidence on record sufficient, appellate court may determine case finally. Where the evidence upon the record is sufficient to enable the appellate court to pronounce judgment, the appellate court may, after resetting the issues, if necessary, finally determine the suit. Notwithstanding the judgment of the court from whose decree the appeal is preferred has proceeded wholly upon some ground other than on which the appellate court proceeds. Now, Your Lordship will see, we have enough evidence. The parties has produced evidence in the trial court. So there are enough evidence for the learned first appellate court to pronounce judgment in this case, my lord. However, without looking in that aspect, the learned first appellate court simply remanded the case back for de novo trial from the stage of settling of issues, where in fact the issues framed by the trial court is enough to determine the case, Now, Your Lordship will again see at Rule 23A, Order 41, Rule 23A, where the court from whose decree an appeal is preferred has disposed of the case otherwise than on a preliminary point, and the decree is reversed in appeal, any retrial is considered necessary. The appellate court shall have the same power as it has under Rule 23. The learned first appellate court has not decided anything that retrial is necessary in this case. Now it has not reversed the appeal, it has simply set aside.
Back.
Yes. Now, Your Lordship may kindly come to the order passed by this honorable court on 9/9/2024.
That is page?
No, the order passed by this court on 9/9/24.
Okay.
Where
In
the substantial
this
question,
case.
yes, where the substantial question of law was framed by this court.
Order dated
9/9/2024. Now this appeal was admitted on the following substantial question of law, my lord. There are two substantial questions of law frame. With your lordship permission, I'll read this.
Yes.
Whether the first appellate court erred in law in remanding the case for de novo trial, as the suit in question had not been disposed of on a preliminary point by the trial court, and considering that the decree has also not been reversed in appeal. Number two, whether the first appellate court has sufficient material or evidence on record to determine the case on merit. Now, as I have submitted earlier before your lordship, there are enough evidence wherein the learned first appellate court can decide the case, even the counterclaim of the defendant number 1 and 2. And interestingly, before this court, the defendant number 1 and 2 did not come before this court, because even though they have received the summons, they would not like
Notice
to
complete.
Notice is complete. So the government respondent 3 to 7, actually they have no interest in this case, because our prayer is very limited. It is only, our prayer is to set aside the learned order of the learned first appellate court and to direct the learned first appellate court to decide the case on merit. There is a judgment of the Honorable Supreme Court, which I would like to rely, my lord.
1 and 2.
Where remand cannot be done casually, my lord.
Is there an order of this court regarding the notice that it is completed?
Yes, my lord.
Order dated?
I'll come to that.
Yes. Yes, 2023 live law. Para?
Page 5, 8, and 9, para. My lord will come. My lord will come at page 8, para 32.
Page 8. Para 32.
Yes, madam. At para 9, it refers to the CPC, and at para 32, it refers to the one judgment of the Honorable Supreme Court itself. I'll also produce that.
Okay.
Here it says, my lord, may I read this?
Yes.
A distinction must be borne in mind between diverse powers of the appellate court to pass an order of remand. The scope of remand in terms of Order 41 Rule 23 is extremely limited. The suit was not decided on a preliminary issue. Order 41 Rule 23 was therefore not available. On what basis the secondary evidence was allowed to be led is not clear. The High Court did not set aside the orders refusing to adduce secondary evidence. Order 41 Rule 23 subclause A of the Code of Civil Procedure is also not attracted. The High Court had not arrived at a finding that a retrial was necessary. Simply in this case also, there is no finding that a retrial is necessary, my lord. The High Court again has not arrived at a finding that the decree is liable to be reversed. No case has been made out for invoking the jurisdiction of the court under Order 41 Rule 23 of the court. An order of remand cannot be passed on ipse dixit of the court. That is the case which I am relying upon, my lord. Now, the case which was relied on that case is 2008 8 SCC 485, my lord. 2008.
So this municipal corporation.
Yes,
case.
Municipal Corporation Hyderabad versus Sundar Singh. So, this paragraph, page 496, para 32, 33, and 34, was referred in life law that Sirajuddin case, madam. Page 496, para 32, 33, and 34.
32, 33, and 34.
Yes, my lord.
Okay.
Now, with your lordship permission, I'll continue.
Yes.
The three issues which were framed by the trial court is enough to dispose the appeal on merit, my lord. If I may read out the issues, my lord. Number one is the court was called upon to decide whether the plaintiff is the owner of periodic pata number 377 of 1978. That would be on page 78, my lord. Page 78.
Whether the plaintiff is a legal owner.
Yes, these issues is decided in my favor. Another point, point number 2. Whether revalidation of periodic pata number 377 of 1978 and transfer in the name of plaintiff was illegal or not. Now, here the learned trial court has also decided in my favor. It has been done by the concerned authorities legally. So that is on page 79 and 80, madam. Now, the issue which would cover the case of the defendant number 1 and 2 is covered by the last issue, my lord.
Okay.
Whether the LSC number so and so and LSC number so issued in the name of the defendant number 1 and number 2 is illegal or not.
Illegal or not.
Now here, the learned trial court was of the view that it was illegal and it therefore set aside the LSC.
Okay.
Now, the defendant number 1 and 2, your lordship will see that they have filed a counterclaim, and their counterclaim was answered by the trial court by framing these issues, madam.
Where is that?
The counterclaim.
They filed a counterclaim in this case, particular case.
Yes, in civil suit, madam.
In civil suit. Okay.
Counterclaim is at, prayer is at page 137 to 138. 137 to 138. Your lordship will come at page 29. That is the prayer portion of the defendant number 1 and 2. Page 137, madam.
137. Yes.
These are the counterclaim.
Page 137.
Now, in the counterclaim, they are asking for the declaration that the periodic pata issued in my name should be declared null and void. And they are also asking for the LSC issued in their name to be valid, madam. These issues has been taken care of by the learned trial court. Now, this aspect of the matter has not been taken into consideration by the learned first appellate court. The learned first appellate court erred in coming to a conclusion that the counterclaim raised by the defendant number 1 and 2 has not been taken into consideration by the learned trial court.
Whereas trial court had considered the counterclaim and come to this finding.
Yes, correctly. I agree with your lordship. So there is a law which clearly says that the situation where a case can be remanded by the appellate court, and that has not been satisfied by the learned first appellate court.
Claim and arrived at a finding.
So to put it short, my lord, my simple prayer is that since there is no finding as to such that the retrial is necessary, and there is no order that the decree is reversed, and there is no finding that this case was decided, the civil suit was decided on a preliminary point, the learned First Appellate Court could not have remanded back the case. So my simple prayer, Your Lordship, at this stage, is to set aside the order of the learned First Appellate Court, that is learned Additional District Judge Aizol, that is order dated 7/9/2023. Let the matter be remanded back and directed the learned First Appellate Court to decide the case on merit.
On merit.
That is all my prayer, my Lord. And the state respondents, they have nothing to say, my Lord.
You have nothing to say.
I believe they have nothing to say, my Lord.
They may have something.
They may have something. I'm sorry.
May I please, Your Lordship, my Lord, I'm the newly appointed GA.
Yes.
So this case has been recently endorsed to me.
Okay.
So I have checked the files and no instruction has been received as of yet now. So
But basically, dispute is between the
exactly, my
appellant
Lord.
and the.
I have gone through the files,
yeah.
but
Yeah.
my submission may be reflected, my Lord, in the order. So
Recently handed over, no?
handed over, my Lord. And I have not received the instructions as
Instruction,
of yet, my Lord.
And he doesn't need instruction also, my Lord.
Yes.
To my
Because
humble
this is
opinion.
only law point, legal point. Actually.
It's only a legal point. My simple prayer is that let this First Appellate Court order be set aside and let the First Appellate Court be directed to decide the case on merit. I may have won in that case. I may not succeed in the First Appellate Court. But my simple prayer is that let the First Appellate Court decide the case on merit.
Just let me see the appellate court order once more.
Malo.
Where is that?
Page 29 to 41 is the order of the learned First Appellate. Your Lordship will come at the operative part, page 41.
41.
Yeah. Yes, Your Lordship. Para 11.
Yes. Okay. Just read again.
With the above reasons and finding, the instant appeal is allowed to the extent that the impugned judgment order dated 18/10/2021, along with the decree dated 18/10/2021, passed by the learned senior civil judge for Aizol district in civil suit number so and so is set aside and caused due to non-consideration of counterclaim preferred by the appellant defendant number 1 and number 2. The suit is sent back for de novo from the stage of settlement of issues in relation to the counterclaim made by the appellant defendant number 1 and 2. Here also, my Lord, the First Appellate Court has not relied upon any order of the CPC wherein remand can be sent, the case can be remanded back, either under order 41.
So your submission is, while framing the issue, even this counterclaim was taken into consideration and altogether the issue was framed.
Yes, evidence was adduced.
On the counterclaim also.
Yes, my Lord. So that is my humble and simple prayer. Let this order of the learned First Appellate Court be set aside and let the direction be given to the learned First Appellate Court to decide the case on merit.
Okay. Heard the learned counsel for the parties. Order reserved.
Deeply obliged.
My Lord, one more thing, that my prayer for getting the instructions may be reflected. My
Yes,
Lord.
yes, surely.
My Lord.
Surely.
Just to be on the safer side, my Lord.
Yes, yes, I understand. I was also in the government panel, so I
Deeply obliged.
May I seek your Lordship indulgence in making a mention in part 2, item number 13, my Lord.
Item number?
13.
13.
Yes, my Lord.
Yes.
My Lord, if this matter may come up after a week or as per the convenience of the court, my Lord.
After a week. Okay.
Yes,
Item 13. On the prayer of learned counsel for petitioner. For appellant.
For appellant, my lord.
List the matter after 1 week for hearing.